Hi, my name is Jane McElligott. I'm a full-time faculty member here with the Legal Support and Services at Purdue University Global. And I am here to talk about the case of Dobbs versus Jackson Women's Health Organization. So this is the very controversial decision that overruled Roe v. Wade and Casey versus Planned Parenthood. So we'll talk about this in the context of stare decisis, which is all about following precedent, as well as due process, and kind of take a quick look at previous decisions leading up to this recent decision by the U.S. Supreme Court. So the concept of stare decisis really means that in Latin, it means let the decision stand. And the court views that as the preferred course because it makes the law predictable, uniform. It's kind of this consistent development of legal principles. And this quote was from Justice William Rehnquist about how it's so important to follow stare decisis because it fosters reliance on judicial decisions and also adds to that the integrity really of the judicial process, that people don't start to question why one court decides one thing and the next court, the next group of justices, I should say, reverses that. So there's more consistency. Usually the court does follow precedent unless there has been some type of evolving social view. And in this case, we don't really see that on the issue of abortion. So that really the public view on that has remained pretty much the same previous to this decision and after this decision. So in this case, in Dobbs versus Jackson Women's Health Organization, it does do a good job of illustrating how the court sometimes, it's especially the recent, the justices on the court in, say, the last couple of years, have not really been sticking to the principle of stare decisis. We saw that in affirmative action and in some other areas that we'll get to in other videos. But let's take a look at this case by looking at the background and of due process as well. So due process, the concept of due process, of course, it's found in the 14th Amendment of the Constitution, but it's all about fairness. It's substantive fairness in the sense that the government, there are certain rights that the government should not mess with, and those are fundamental rights. And so we'll look at that list down here, the right to marry, and that's regardless of race, national origin, sexual orientation, because of Supreme Court decisions carving those rights out. The right to die for the terminally ill, the right to bodily autonomy, the right to send one's child to private school even, and the right to contraception. So these are thought to be private autonomous decisions that the government should not interfere with. If the government procedural fairness, the other one is that if there is something the government is doing that in some way affects our life, liberty, or property, it has to do so with proper notice, a fair hearing. That's procedural due process. To really get the gist of substantive due process, let's take a look at the case of Griswold versus Connecticut. So this is a 1965 case. And here's a picture of Estelle Griswold, who was named in the case. She was the executive director of Planned Parenthood in this particular center was in New Haven, Connecticut, and that picture is from 1963. So in this case, it actually involved the doctors at Planned Parenthood were giving out contraceptives to married couples who asked for them. And so the state of Connecticut arrested these doctors and charged them with violating this law that prohibited the giving out of contraceptives. The court in this case struck down that law and said that this is part of the right to privacy. And that right prevents the state from prosecuting doctors from providing contraceptives to married couples. And the court emphasized that the right to use contraceptives is a private decision. It's a fundamental right with which the state does not have authority to interfere. So it's substantive due process. Justice Douglas, in his opinion, it was a very powerful opinion, and he looked at the Bill of Rights and the first 10 amendments to the Constitution. And he looked at, for example, the First Amendment. There's a right to freedom of speech. There's a right to freedom of association. There's the Fourth Amendment, the right to against unreasonable search and seizures. Even the Third Amendment provides that the colonists back in the days of the Revolution didn't have to quarter or board the British soldiers. So even that is a form of privacy. The Fifth Amendment, the right against self-incrimination. The Ninth Amendment basically says that even though there are certain specific rights listed in the Constitution, that doesn't mean there aren't other rights that are out there that just were not put into the words of the Constitution. And of course, the 14th Amendment and due process were all of the provisions that he pointed to. And so he said that the specific guarantees in the Bill of Rights have penumbras, and a penumbra is kind of like a shady area, sort of an extension of the specific rights. And he said these penumbras are formed by emanations from those guarantees that help give them life and substance. Various guarantees create zones of privacy. So by pointing to the specific rights and then saying, there are other rights that just weren't listed, but are certainly among this right to privacy. It was a very interesting and powerful way to create this, or not create, but establish this right to privacy. So this right that was established in Griswold was then extended in Roe v. Wade. So in Roe v. Wade, the court pointed to Griswold as one of the precedent cases following stare decisis. And in Roe v. Wade, the court included in the right to privacy a woman's decision whether to terminate her pregnancy. And this was within strict timelines as well. So in Roe, the court had set up what was referred to as a trimester framework. So in the first trimester, the first 3 months, the state could not ban or restrict abortion. But in the second trimester, the state could regulate abortion to protect the health of the mother. In the third trimester, the state could step in and ban abortion, because then the state had an interest in the fetus as well at that point of the third trimester. But in situations where the mother's life or health was at risk, then the state could not do so. And in this particular case, the law being challenged was a Texas abortion law. And the court struck it down because it banned abortion unless the mother's life was at risk, rather than just her health. So even if the mother's or the woman's health was at serious risk, the state was not allowing abortion in that case. So the court said, no, that is not constitutional to do that. Planned Parenthood versus Casey, SCOTUS followed up and strongly reaffirmed its ruling in Roe. And it struck down a Pennsylvania law that required married women to notify their husbands before having an abortion. And SCOTUS in that case, while it reaffirmed the framework of Roe, it also came in with a new standard called the undue burden standard. And the court said that a state cannot place an undue burden on a woman's right to choose to have an abortion, and that requiring such notice would be an undue burden. So, for example, in a case of, say, there was domestic violence, and perhaps the husband wasn't willing to give that consent, in that case, that could be a serious undue burden on the right to abortion. So again, SCOTUS reaffirmed Roe in this case, and in fact, it did so in the very first line of its decision in Casey, stating that liberty finds no refuge in a jurisprudence of doubt. So the justices emphasized the importance of, letting people know that that the right to abortion is a constitutional right and that it is not in doubt. In Dobbs, though, which was decided in 2022, June of 2022, SCOTUS overruled Roe v. Wade, and as well as Casey, because that was relying on Roe, really upending 49 years of precedent, so only almost 50 years of precedent. In Dobbs, SCOTUS, and this is a 5-4 opinion, so a very close opinion by Justice Samuel Alito. The Chief Justice, Roberts, actually did not join the majority opinion because, while he believed the law at issue, the abortion law at issue that we'll talk about, was constitutional and should be upheld, he did not think the court should overrule Roe. But the majority here declared that the court's decision in Roe was egregiously wrong and deeply damaging and should not be allowed to stand. And this is despite the principle of stare decisis. So basically, Alito decided that the previous justices in Roe and in Casey had made the wrong decision, and they were completely wrong. That was his view, and so then he proclaimed that the issue of abortion should return to the people's representatives, meaning state legislators. He noted that abortion is not specifically included as a right in the Constitution, which really is not surprising, that the founding fathers of the Constitution didn't include abortion. I mean, there's many rights that the founders may not have considered, and of course there weren't founding mothers who may have considered that. Alito acknowledged that SCOTUS has recognized some constitutional rights as protected by the Due Process Clause, even if they're not expressly mentioned in the Constitution. But he said the right to abortion is not one of them. He asserted that for a right that is not expressly stated in the Constitution to be worthy of constitutional protection, the right must be deeply rooted in our nation's history. And so in Alito's assessment, abortion didn't meet this qualification because at the time, if you look back in history, most states considered abortion a crime until about the late 1960s was when the first states started to decriminalize abortion and start to recognize it as a right. So once Alito made that determination that abortion is not a fundamental right protected by the Constitution, he then applied what's known as the rational basis standard of review, which is a very easy standard of review that pretty much allows the government to pass any kind of legislation it would like, as long as there's some type of rational basis for it. And applying that test in this case led the court to uphold this Mississippi law. The law, it being challenged in this case, imposed a ban on abortions, pretty much all abortions, after the 15th week of pregnancy. It did have an exception for medical emergencies and cases involving a severe fatal abnormality. But there was no exception at all for cases of rape or incest. The federal trial court that first heard this challenge, and then the U.S. Court of Appeals for the Fifth Circuit, both blocked that Mississippi law, saying that no, this is completely contradictory to Roe and to Casey. But after SCOTUS decided this case, Mississippi and all the other states were pretty much given the green light to go ahead and enact restrictive abortion laws such as this one with no interference from the Supreme Court. And several state legislators prior to the Supreme Court overturning Roe had already passed what are referred to as trigger laws. So they were just ready to go into effect once SCOTUS overturned Roe. So they just sprung into effect, and they were much like the Mississippi law, very restrictive. Um, Even, again, even in cases of rape or incest, and even in cases where the mother's health was at issue, there was no no exception allowed. So what the result has been is that there's been this really chaotic patchwork of laws. And so it depends, the right to abortion basically depends on where one lives. And if we take a quick, I'll come back to this, but take a quick look at this. This is the Guttmacher institute that does amazing research on this issue. And as you can see there, it's just this incredible patchwork that kind of makes no sense. But the deep maroon is the most restrictive. The red is, or orangey red, is very restrictive. The gold is restrictive. So as you can see, there's quite a bit of restrictive legislation. Uh, not even, not even 1 year out from this decision. And it continues, state legislators continue passing such laws that are very restrictive, that would never have been allowed under Roe and Casey. I'm just going back here. I did want to, I already mentioned that, but it is important to note how Chief Justice Roberts decided not to join the majority opinion, because he believed that Roe v. Wade should not have been overturned because of the idea of precedent. There was a very powerful dissent in this case. And in fact, usually the justices don't join in what is referred to as a joint dissent. But this is one rare case where the justices did. And so it was Justices Breyer, Sotomayor, and Kagan, who are known as the more liberal justices, joined in and strongly criticized the majority. And they contended that under the Constitution, there are just some issues, such as abortion, that should remain off limits to majority rule. In other words, when a right is a fundamental right protected by the Constitution, it shouldn't just be thrown to state legislators to handle, because that becomes majority rule, and it's too easy for constitutional rights to be suppressed. So the dissenting justices denounced the majority opinion as a violation of women's autonomy, and they asserted that this decision would harm the court's legitimacy and jeopardize other rights. So they pointed to other rights within the right to privacy, such as right to contraception, same-sex marriage, pointing out that these rights are part of the same constitutional fabric as the other rights that form the right to privacy. And they saw through the writing of the majority opinion, and even the concurring opinions pointed out, oh, this isn't going to impact other rights within the right to privacy. But the dissent pointed out that pretty much, we don't believe you, that those rights are going to be gone next. So kind of pointing out that this could probably be one scary decision of many others to come in the eyes of the dissenting justices. So the dissenting justices powerfully condemned the majority's decision to overrule Roe and Casey as a betrayal of the court's guiding principles, and pointed to this principle that was voiced in the Casey decision by the plurality of justices, where they said the public should never conclude that its constitutional protections are hung by a thread. That a new majority could, by dint of numbers alone, expunge their rights. And so the justices feel that this is exactly what the majority opinion did. I'm sorry, the dissenting justices. And they wrapped up their dissent by saying, with sorrow for this court, but more for the many millions of American women who have today lost a fundamental constitutional right, we dissent. And what was even interesting is, oftentimes in a dissent, no matter how powerful the dissent, they usually end it with, we respectfully dissent. In this case, they did not. So they were, that shows the level of their outrage at the majority opinion. And so that is all I have. There's a very good, this link will bring you, or you can just Google the Guttmacher Institute. It has this interactive map, so you can click on any state for further information. And this is a really good article. SCOTUS blog has excellent articles about Supreme Court cases. And I think this one does a good job of outlining the Supreme Court decision in Dobbs. So thank you for listening. Take care, everyone.